guys. Okay, so we're back, and I'm here with Mr. Charles Rambo. He has been on this platform several times, bringing us the latest updates when it comes to Fulton County, whether it's the jail, Sheriff LaButte, and more specifically, Fani Willis. Now, we all know Fani Willis lost in court again. She has to pay $54,000 to Ashley Merchant's law firm because she violated the Open Records Act law. But the question here is, because we're not going to dissect what went wrong, or I mean, we can, but the question that I want to ask you guys of Fulton County of Georgia and everyone else watching, and of course, Mr. Charles Rambo, who foots the bill? Because the taxpayer should not pay for her corruption, should not pay for her not following the law. The taxpayer should not pay for her F ups. So, Fulton County Commission, they had a meeting on Wednesday, March the 19th, I believe, and they were discussing who's going to foot the bill. But I wanted to bring on Mr. Charles Rambo to discuss it because he lives in Fulton County and he always has his ear to the ground, and he comes here with a lot of valid factual information. So, how are you, Mr. Rambo?
I am doing good, and as always, you're looking gorgeous in that cowgirl hat.
Thank you. I appreciate that. So, tell us what is going on with the $54,000. Are the taxpayers going to be paying for it? Just give us a summary of, up to date on the situation with Fani Willis.
Well, I've been following this story more or less because of its impact on the Fulton County criminal justice system. And as everything is continuously mounting up with consent decrees at the jail, as well as how that impacts the district attorney's office in terms of speedy trials, not getting inmates out in a timely fashion, what have you. Here's another expense that's getting ready to be passed on potentially to Fulton County residents, taxpayers. And I am a Fulton County resident. I've worked in Fulton County's criminal justice system, and this is just becoming alarming. And what has happened as a result of the monies that were due, or should I say that the judge ordered for the district attorney's office to now pay as a result of the open records request from the merchant firm. They have now determined that there will be I can't say a fine or assessment. Well, yeah, basically a fine for those open records and potential awarding of attorney's fees. With that, the Board of Commissioners on yesterday introduced a resolution essentially coming in to say to the General Assembly that is still in session right now, we don't want to be the recipient of those of those fines that will now be passed back to Fulton County residents to pay for. Whether this is this district attorney or any other district attorney or any other constitutional office, I believe because of the fact that these are constitutional offices, these definitely, specifically representing the interests of the state needs to take up the burden for some of those particular missteps, or when their constitutional officers are not consistent with what the law dictates about their duties and roles. So they basically have passed this resolution to allow for their legislative aid to go and to basically retort against the county having to pick up anything, whether it be for prosecutorial misconduct, whether it be for whatever it might be, push that back to the state. And I agree with that, rightfully so.
We're going to play the segment during that Fulton County Board of Commissions discussing who's going to foot the bill for her F up. So I want to play that clip. It's about what 15 to 20 minutes, but I think it's very it gets spicy. You said it gets spicy, but I think it's very insightful for the public to see how these issues are discussed, and worked out.
Urging members of the Georgia House of Representatives to protect Fulton County taxpayers and Georgia taxpayers by voting no on Senate Bill 244 regarding the assessment and payment of costs of criminal proceedings and for other related purposes, sponsored by Commissioner Barrett.
All right, Commissioner Barrett.
Thank you, Mr. Chairman. I want to start by saying I absolutely support prosecutorial oversight. I think there's a time and place for that, and I support that. But I think SB 244 is not quite getting it right for a couple of reasons. I wrote this resolution when the bill had just passed the Senate, and so I wrote it at the time with the help of the county attorney's office, based on the original text that was in this bill as passed the Senate. To my understanding, and I think Ms. Corbett sent us some information about the fact that there is now a substitute bill. And the substitute bill did address one of the big issues, which was that in the way it was originally written, we would be on the hook, so to speak, for defendants' fees if a prosecutor was disqualified, but even if the case was not dismissed. That's how it was originally written. That has been corrected in the substitute bill, so that problem is off the table. But the biggest issue here is who pays, and that is at the moment in this bill set to be us. This money would come from our general fund to pay the defendant's reasonable legal fees and costs in the scenario in which a prosecutor is disqualified and then the case is dismissed. There's a new problem in the substitute bill, which is that there's no correlation in the writing of the substitute bill between the disqualification and the dismissal. That was in the first version, but in this case, it's saying if a prosecutor is dismissed and the case is later, if a prosecutor is disqualified and then later the case is dismissed for any reason, that we would be on the hook. And there are lots of reasons cases can get dismissed that have nothing to do with prosecutor being disqualified. So I think that language, I'd like to certainly get across to the folks in the House and the Senate, if they end up having to vote on it again, that language should be tightened up. But the biggest issue, of course, for our taxpayers is that this is set to come from county coffers. And I see that as a fallacy because the district attorney is a state constitutional officer. And as we all know, and have discussed on more than one occasion, when there is a legal action against the district attorney, it is defended by the attorney general of the state. It's not our county attorney that defends, it's the state that defends. And if there's a judgment in those cases, it's the state that pays. So this should be the same. If there is a problem with the prosecutor, then the state should pay the bill. That would still solve the problem for the defendants who may need a remedy if they were unfairly tried, but having it come out of the county coffers is not the right place for it to be. So the goal of this, I'm very open to friendly amendments on language here because the bill has already changed. And I asked the Madam County Attorney to sort of opine on a couple of places where we would need to fix the language, but I think, and I'll ask you to share those in a minute, Madam County Attorney, but I do think that us either saying we would like them to oppose the bill altogether, which is how it's written right now, or at least amend the bill so that the monies are coming from the state where they should come from versus us. Either way, I think would be acceptable from my perspective. Madam County Attorney, can you just talk about how the changes we would need to address the bill as it's currently written?
So as I understand it, there were, in the original version of the bill, there were two separate paragraphs regarding the conditions that would trigger this type of payment of attorney's fees. And in the newer version, it's my understanding that those two paragraphs have been combined. So I think if this were to pass, we would tweak the language after its adoption so that the resolution that originally had two separate paragraphs mirroring the original version of the bill would then be combined so that it matches the newer version of the Senate bill.
Okay, so I'm fine with that. I don't know that I don't know if y'all are going to support this or not, but I hope that you will in favor of looking out for our taxpayers in this case. I recognize that these types of prosecutorial disqualifications aren't super common. However, I think we all know the elephant in the room case is the Trump case, and there are, potentially millions and millions of dollars here that are going to be gone after, and that would be coming from our coffers. And I think we need to, not only be questioning the motives here, but also looking at the, where the money should legitimately come from, if there should be a remedy, and that's a question for everybody to answer, I guess, in their own mind. But if there should be a remedy, it should be coming from the state. It's the state's job to defend and, pay any judgments on their state constitutional officer, their employee. We pay the supplemental salary, not the salary. So I do think it's not right the way it's written, and we should defend our county government and our taxpayers. So I welcome comments, questions, amendments.
Commissioner Thorne? Just a minute.
Oh, sorry.
Commissioner Arrington's not it. No.
Oh, okay, I'm sorry. I am just not fond of urging resolutions at all, especially since this resolution passed the Senate unanimously, 55-0. The Democrat Senate Minority Leader Harold Jones said, if you have that young person, possession of marijuana, whatever it may be, and the prosecutor had won something wrong, and that case is dismissed because the prosecutor did something wrong, they are entitled to have their attorney fees back. That's actually something that we probably should have pushed for years ago. So for me, I'm into protecting justice. If we have someone prosecuting a case and they are improperly disqualified, then whoever it may be, I'm sorry it's going to be, Trump defendants. You might have an issue with that, but they should get their money back. I think it's hypocritical to say we're protecting the taxpayers' dollars when our district attorney entered into this case costing us millions of dollars. Even with one attorney, it was like $750,000 taxpayer dollars. So if we really want to protect taxpayer dollars, we should look at getting costs that she's incurred in this case, and now this case is thrown out the window, as well as the YSL case is thrown out the window, and it's cost the taxpayers millions and millions of dollars, not to mention the time while our jails are overcrowded and the court system has been clogged, the time that was invested in this, and now is costing the taxpayers indirect dollars. We just this week, we had a $54,000 judgment for violating an open records request. Last fall, we had a $25,000 violation from the open records request from the district attorney's office. So I fully agree that the state should probably pay for these fees, because she makes it clear she is a state constitutional officer. She is not a county constitutional officer. Many district attorneys span various counties, so it would be impossible to divvy up that in another case statewide. So I think the state should have to pay those costs, as well as these $54,000, the $25,000, and anything else that she's incurred for her improper handling of the case. So anyway, I think we have to look at what's just for the people in this case, and it might hurt, doing the right thing, but I think we need to do the right thing and pay them back.
Commissioner Arrington?
Thank you. So Senate Bill 244 is it gets it completely wrong. As an attorney that has been practicing law, continuing to practice law for the last 29 years, since 1996, there is a difference between disqualification and prosecutorial misconduct. Senate Bill 244 gets it wrong because it tries to make disqualification equal or the equivalent to prosecutorial misconduct. There are many reasons for which a prosecutor could be disqualified. A prosecutor could withdraw and refer the case to the PAC-GA and be disqualified. They could disqualify themselves. A prosecutor can disqualify themselves. The issue is prosecutorial misconduct. Now, additionally, Senate Bill 244, at least the intent of it, the intent of Senate Bill 244, or the idea that it could apply to the Trump case, is unbelievable. No, better yet, unconstitutional. It violates the Georgia Constitution and the United States Constitution. You cannot pass a law that goes backwards. You did something yesterday and we said it's wrong today. No, that's unconstitutional. It has to be the law already. The law already has to be in place. People have to have notice that it was wrong to do it on the front end. You can't make a law and say, we're going to go back. We're going to go back and hold you liable for the law we made tomorrow. We're going to make a law tomorrow and you did something wrong yesterday. It violates the Georgia Constitution, the United States Constitution, logic, and everything else. So even if they pass it, it's unconstitutional. You cannot go backwards. No law can be applied retroactively. But more importantly, you have to know the difference between prosecutorial misconduct and disqualification. There are numerous ways in which a prosecutor can be disqualified. But that doesn't mean that they committed prosecutorial misconduct. It doesn't mean that they committed prosecutorial misconduct. And so I am of the belief, and I'll make the motion that we speak loudly against Senate Bill 244 and oppose it in its entirety. The amendment, the reason that it passed 55-0 is because and I'm not going to call any names. Someone lied. Someone lied and said the substitution would not make it apply to the Trump case. And that's not true. The substitution removed one section. It removed one portion of one section from subsection C and left in place subsections A and B. And so if it goes to the House and they make an amendment, it's going to have to go back to the Senate, and I guarantee you not one Democrat will vote for it. Not one. So, not only because it doesn't make sense and they don't know the difference between disqualification and prosecutorial misconduct, but because also it violates the Georgia Constitution and the United States Constitution.
What the hell was he saying? He lost me.
Well, essentially, and I want to come back and I want to correct a statement I made earlier in terms of prosecutorial misconduct as opposed to the disqualification. I meant to say that earlier, not the misconduct. Commissioner Arrington, of course, is a local defense attorney and essentially is stating his understanding of the law. Let me back up before I come in at my interpretation of what he's saying. In Georgia, why this is so important is that constitutional officers that are elected represent the interests of the state at the county level. So with that, you have to, number one, be an elected official, and number two, you have to squarely represent the interests of the state, such as the district attorney, the sheriff, the superior court clerk, the tax commissioner, as well as the probate court judge. Under the 11th Amendment of the United States Constitution, it essentially bars lawsuits from those state actors that perform duties on behalf of the state, that gives them I can't say a degree, but gives them sovereign immunity, that when these type of things come up, whether it's misconduct, whether it's disqualification, whether it's errant performance of your duties, or should I say questionable performance of your duties, the state will come in and say, so long as you have followed the law, you have done it in a manner that is consistent with training, policy, and supervision, the state will now invoke and say, you cannot sue our actor of the state because they did the job at least within side of what he just said, the state constitution as well as the federal constitution. When you don't perform your duties in that particular manner, the state takes its hands off and say, now that's between you and whoever else is going to pick up and foot that bill. This is especially important and critical, not just to the district attorney, but even the sheriff's office, consistent with what they just said, that this is now just as impactful with all the issues going on in Fulton County of the overcrowded jail. Well, at the end of the day, overcrowdedness is an unconstitutional condition that a sheriff as well as the district attorney share a responsibility for. And I believe this consent decree that we're currently facing under the current sheriff needs to be a responsibility of the state as well, because of the fact that the county jail is an extension of the state government.
So my question is,
Ma'am?
my question is, this guy here, is he saying that the state should not pay and we should, or that the state should pay? Because he's going back saying you can't make a new law for this and a new law for that. What exactly is he saying?
Well, and that's, I mean, it flows right into that. And just to speed up, to your square question, what I believe I thought I heard hearing him say, as all of them eventually vote, I think it was a 5 or 6 majority vote to pass this resolution, is to say that depending upon whether it was disqualification, whether it was misconduct, whatever it may be, it should be at the state level that it should be paid and should not be trickled down to the county coffers. But at the end of the day, that's where the sheriff, the district attorney, and any other constitutional officer, you just don't come in and flex your muscles saying, I'm a state constitutional officer. Well, then damn it, at the end of the day, your job should be performed in such a constitutional manner consistent with the state and federal constitutions that it would eliminate these type of issues. It would now bear upon the state to say they did the job appropriately and correctly, therefore we're not going to allow you to sue our actors.
All right, I want to finish.
Okay.
Barrett?
Commissioner Barrett, thank you. Madam County Attorney, can you talk about what recourse someone has who was wrongly prosecuted?
So without tailoring it to individual facts, but hypothetically, there is a claim under Georgia tort law for malicious prosecution if a prosecutor or even if any law enforcement entity is deliberately targeting a person for improper purposes through the justice system.
So there is a remedy in some cases, let's say.
Depending on the facts,
Sure.
there is a state law remedy for malicious prosecution currently on the books.
Okay, and the other thing I guess I'm focused on here is I agree with everything Commissioner Arrington said. I don't have as thorough of a reading of the Constitution and whether or not it's against the Constitution, but I do agree that going back in time seems not like, that is something you can't do, correct?
Typically, retroactive application is not something that you can do with legislation. There may be some exceptions, but generally speaking, no. And in its current iteration, I do not read the bill to apply retroactively. I don't know if that was the
Is
intent.
there a loophole there, though? Because I think the way I read it, it says that you would apply this law or this section of the code essentially when the case is dismissed, at the time of the dismissal. And if the dismissal has not happened yet, even though the case was started, it could have been a case that's 10 years old, right? Some of them go a long time. Does it apply to those cases or only a case that's new and started after this law? Because
Well-
that seems like a loophole to me that could be problematic.
I mean, possibly. I haven't researched it for that particular issue. My first thought about that would be that the bad act would be the thing to trigger it. And in this hypothetical, the bad act would have already occurred.
I got you. In this hypothetical, it's not entirely hypothetical. I think, you know, again, my issue here would be that if the intent of, my issue here would be that if the intent of this was really to address that young man as described, or young person as described, that had a $10,000 legal expense for a marijuana charge or what have you, and if that were really the intent of this legislation, that it should have been written more thoughtfully and more specifically to address overall prosecutorial oversight. And that would include where the remedy comes from, what the remedy should be, et cetera, et cetera. So I think, you know, one of the reasons that from, you know, what I've heard, one of the reasons that some of the senators supported this is because it was presented to them as a prosecutorial oversight bill. But then the sponsor of the bill immediately went to the press and said this was because of the Trump case. And so then they were like, well, wait a second. So I don't know who's you know, pulling whose leg here, but at the end of the day, this bill is poorly written, poorly constructed, and the remedy is coming from the wrong place. No matter whether you think that a defendant, even if you think a particular defendant should get, you know, their fees paid coming from the county coffers is flat wrong. So because the time is of the essence, because this is going to happen very quickly over the next few days, I think it is imperative that we oppose this today.
Ms. Ivory?
Thank you, Mr. Chairman. I am opposed to the county being responsible for any fees related to, you know, misconduct or allegations of misconduct, finding of misconduct. And I think that we will soon have our 2025 legislative session update from our External Affairs Department. And I feel that they are the ones that are leading our strategy on what are the important legislative issues to us. So I'm not necessarily sure that we need a resolution urging this one specific thing, as this is something that is in our packet. Ms. Corbett, is it true that this is a bill that you're going to discuss along with a bunch of other bills that are important to us at Fulton County, so that you can take our concerns to the delegation and let them know that more than any part of this writing of this bill, we do not need to be the responsible party, since we don't have any acting besides the supplement that we pay, we don't have any regard for not regard, but we don't have any power over the district attorney in the way that the state does, because she is a state constitutional officer. So you are addressing this with our leaders in the legislature, right? Okay, so then I don't necessarily feel that we need to point this one out specifically when we have a body of bills that we're following. Is that correct? Okay, great, thank you.
Ms. Thorne?
Yes, I just want to read a part of
Like
the
that, I'm sorry. I
Commissioner
referred-
Thorne. Coach, you can call me Coach.
No, I referred to you as Ms. Thorne, Commissioner Thorne.
The bill says an award of reasonable attorney fees and costs in a criminal case to the defendant upon the disqualification of the prosecuting attorney for misconduct. It is for prosecutorial, it's for misconduct in a case, disqualification for misconduct. So I just want to be clear on that. And with that being said, I totally agree with you, Commissioner Ivory, and I want to make a motion to file this resolution. I don't think we need it.
Is that a substitute motion? All right. Is there a second?
Substitute motion.
Second?
Second.
All right. Substitute motion on the floor to file. Commissioner Barrett, you want to be heard?
Whether, look, whether or not you like urging resolutions, they happen on this board on a regular basis. I didn't make up the idea. I'm not the first one to propose one. We have voted yes on them as a body on numerous occasions for a variety of different reasons. The difference between an urging resolution and a lobbying priority is that an urging resolution is a strong statement from the board that we oppose something. A lobbying priority is us trying to get something changed and hoping for the best. No offense to the lobbyists. It's a much more private thing. It's a quieter thing. It's not a strong statement. Having an urging resolution is a strong statement. So, you know, obviously I can't support a motion to file. I think this is too important, and I think it's going to come back and bite us, but you guys will do what you want to do.
Commissioner Arrington?
Thank you. Yes, the reason that this is important for us to make a strong statement today is because there's nothing else on our lobbying agenda that could potentially cost us $4 or $5 million. Ms. Corbett, what else on the lobbying agenda could cost the county $4 or $5 million? It was a rhetorical question.
Okay, thank you. I'll go back to my seat. Thank you.
Nothing. There is nothing. There is nothing else on there that could cost the county potentially $4 to $5 million or more, because if they try to do it, it's absolutely unconstitutional. So then we got to go spend more money fighting to prove that it's unconstitutional. Colleagues, you may not like me, you may not agree with me, but let me tell you something. It is absolutely crucial that we send a strong statement that Senate Bill 244 is wrong. Commissioner Barrett is right. She is a state officer. The criminal cases, do y'all know what the style of a criminal case is? It doesn't say Fulton County versus Marvin Arrington. It says the state of Georgia. The state of Georgia versus the criminal defendant. Why would Fulton County be responsible for paying for someone who's acting on behalf of the state? Why would Fulton County have to bear that burden? Why would the residents of Fulton County have to bear that burden? The prosecutors are acting on behalf of the state. They are state constitutional officers. There is no reason that the county should have to bear that burden. We're already paying for the budget and adding a supplement to the salary. Please, please vote to oppose Senate Bill 244 today, right now. And if you are aligned, boy, you have to watch the company you keep and the people that you are aligned with and the people that are lining up to vote with you.
All right, the motion on the floor is to file, properly made and seconded. Commissioner Ellis, you have the floor. Strike that. Vice Chair Ellis.
Thank you, Mr. Chair. I'll be brief on this. I think the forum for dealing with legislation is fluid. We all know this. We have this during the course of our the time the legislature is in session. The time for us to object or take a position is when we go through our legislative agenda. We went through this. We had a previous discussion. At our prior meeting, there was a bill that we took action on. We all sort of had different sort of expressions about things we might have been concerned about. You know, this might be one too. Several of us may have concerns about the way that the bill is readed, but we may have differences of opinion about the different components of it. And, you know, and may not agree with the language placed in a particular resolution on it. It's not law. It's a fluid process that we're going through, and I don't think this type of process is appropriate for us to go through and take action on it. I think the appropriate venue for it is in the discussion of our legislative agenda, just like we do, and then we can take a position up or down on individual bills as a board, convey our individual feedback, and work through our lobbyist on that. So therefore, I'm in support of the motion to file on it.
Commissioner Barrett.
When we developed our legislative agenda, and you can correct me if I'm wrong, Ms. Corbett, this was not a bill that had been proposed. Is that correct? Yeah, so we could not have decided to oppose this at the time of when we developed our legislative agenda. So, okay. The bottom line is, whether you like the language or you don't like the language, the fact of the matter is, this is a state officer. We should not pay the bill. For that reason and that reason alone, we should be opposing this bill. We can put the whole rest of the conversation, the intent, the language, it doesn't matter. It's not Fulton County's bill to pay. And if we don't oppose this, it's likely going to pass. So we need to do everything in our power to protect our coffers from this law, with this bill that could become a law that would be, or part of the code, that would be holding us to pay this money. And excuse my poor grammar, but this is, if we don't make a strong stance, this is a state responsibility, we are gonna allow this to slip through, and we are gonna be holding the bag when it's over.
Commissioner Ellis.
Yeah. Thank you, Mr. Chair. Commissioner Barrett, I think you missed my point. At our last meeting, we had a piece of legislation which we discussed in our external affairs discussion. It was not part of our original agenda, legislative agenda. It was in response to a bill that had been put forward in the creation of a development authority. We had a discussion within the context of our legislative agenda discussion, and we took a position on it as a board. That's the appropriate venue for this, not wasting the time for our county attorney to have to draft a resolution, dragging us all through this particular discussion, interjecting pieces of this into here that we may not agree with in the components of what the words are in the resolution, but we may disagree with certain parts of the legislation which we want to have our voices go back on. Thus, I think it's different in terms of, don't sort of interject a different thing than what I was saying. I just want to be clear on that.
Commissioner Ivory.
I wanted to say that I agree with Commissioner Ellis in that we're not disagreeing with parts of this, the language of the resolution. I agree with you, Commissioner Barrett, 100% that the county should not be the responsible party. I agree with Commissioner Arrington that the county is not the responsible party. I do not think that this urging resolution will get us to any further point than working through the process that we have in place with our legislative priorities. Plus, it is a public forum, the General Assembly. If we are passionate about this, we can ourselves walk down to the General Assembly and give our thoughts on that. We are the commissioners of Fulton County, and if we need to appear for comment there, we can do that, which is the strongest method of showing what we feel about it. So if we want to come up with some sort of plan of priority along with our External Affairs Department, which goes to the General Assembly every single day to fight for the things that we need, then that's the plan that we should come together to come at it with the strongest support for this not moving forward as it is written. And that's what I'm prepared to join you with if you need that.
Commissioner Thorne.
Call to question.
All right. Is there a second on the call of the question?
Second.
All right. Let's vote on the call of the question.
And the vote is open. I'll call the question. And the motion passes, 5 yeas, 2 nays.
All right, motion on the floor is to file. Let's vote.
And the vote is open on the motion to file.
Well, this says motion to approve.
It says motion to approve.
We don't have file in the
Oh,
system.
I'm sorry. I'm so sorry.
Motion to file is the motion that's on the floor.
And the motion to file passes, 5 yeas, 2 nays.
Next item.
So what do you think?
Well, two things is that, and I hope the Board of Commissioners are listening to me emphatically on this podcast. That is the first time I have heard them speak with such vitality, and it was nonpartisan. This is the type of votes that are needed based upon what is in the interest of what the rule of law states, which now what they're trying to do is to ensure that they have that protection at the county level if this is able to push forward. So congratulations, Commission, for essentially making a nonpartisan vote that made sense. The bag up to that of it is that as you were asking earlier in terms of what Arrington was talking about retroactively, whether it's retroactive or whether it's foresight moving forward. This could also set the precedent that anytime an inmate feels or wants to file that they were exonerated and they're coming back to collect attorney fees or what have you in terms of that disqualification or that misconduct. We've had several cases that have been publicized here recently where the DA has essentially come in and dismissed a lot of those cases before they went to trial. Well, at the end of the day, now it comes back again upon both the sheriff as well as the district attorney. Well, I've spent damn near 2 years inside of jail. Somebody's got to pay for that particular oversight of me sitting here for such a long time, not being able to get a speedy trial as you would have filed or what have you. So this very well could set a precedent that these type of lawsuits, fines or what have you, and collection of attorney fees could add up to be very expensive.
So here's my thing. I'm glad that they passed this resolution to where they do not want Fulton County to be on the hook to pay Fani Willis legal fees. She is employed by the state. It is a state issue. The state should be responsible paying for her legal fees. Now, with that said, like Rambo said, there are going to be other cases coming after this, filing charges against her office. They're going to most likely win, and they're going to seek damages. Should Fulton County still be on the hook? Absolutely not. So you're talking about millions and millions of dollars down the line with other cases against her DA office. And they're going to most likely win these cases against her office. And it's going to be millions of dollars in restitution. And the state should be the ones responsible for paying for it. And if they don't want to pay for it, then make Fani Willis pay for her portion of the $54,000. But there are going to be other cases down the line that's going to they're going to demand justice. They're going to demand restitution, and of course, the lawyers, the law firms, they're going to want their money and their retention, right? So the state should be on the hook for these fees. And if the state realize we're going to be kicking out not just $54,000, but possibly millions of dollars from all the residue that's going to come after that. Because mind you now, the state of Georgia passed a law allowing defendants, not just in this Trump case, but in all cases, but specifically in this Trump case, they are allowing defendants to sue Fani Willis' office. So if they win their lawsuit, other defendants who had cases going through her office are going to file a lawsuit as well. So the state of Georgia may be responsible and on the hook for a multi-million-dollar payouts. I'm just saying. So she's either going to have to step down or resign. Most likely, Fani Willis is going to resign from her post. And the reason why she will most likely resign from her post, because there's too much heat. It's too much heat from the county, too much heat from the state Senate committee, and then she has to deal with the feds, with the federal government. It's heat coming from Congress. So she needs to save face, do her own self a favor, and save her own ass, and just resign from her position. Thank you guys for tuning in, and I will see you in the next episode of Dana with the Data. And thank you to Mr. Charles Rambo for joining us today.
Dana with the Data. Dana with the Data.